Hi, this is Lisa Runquist, professor for the Religious Organizations class. This is regarding Unit 2 on formation and governance structures of religious organizations. A lot of this you have a basic idea of because of the class that you took before on nonprofit organizations. But because there are so many things that are specific to religious organizations, we're going to be talking to some degree about a lot of things that you may have already covered. Feel free as you're going through to apply anything you already know, but we want to make sure that you understand the issues with regard specifically to religious organizations. Now, there are several different types of structures that can be used for churches and have been used for a lot of different churches. The one that should be mentioned, because it's probably the oldest form that has been used in the United States, is the trust form. In fact, there are several states, Virginia and West Virginia, that up until recently did not allow churches to incorporate, and so as a result they were generally formed as trusts. There are some benefits of being a trust. A trust is not required to file anything in order to establish the to establish the organization. They still may be required to file to establish exempt status if they are not a church. But for churches, trusts really don't have to file anything in order to exist. Unincorporated associations, again, there's a reason why you may use an unincorporated association. In fact, a number of churches have. It's something to consider if you're concerned about the government oversight of the church. So either a trust or an unincorporated association might be used. Unincorporated associations, again, do not need to file anything with the state in order to exist. Limited liability companies often are being used for subsidiary organizations for nonprofits. For example, if you have if you're forming a number of nursing homes, it could be that you have one nonprofit corporation and then you have a separate LLC for each home, so that you're not putting all of the assets at risk if there's some liability that results from what happens in a particular home. Up until just recently, there was no question that the IRS considered the only LLC that would be exempt to be that which had as its members other nonprofit exempt organizations. There's some indication that perhaps they're realizing that you can have an LLC just like you can a trust or an unincorporated association and have it function with members that are individuals, as long as you have provided the protection in the LLC documents that make it clear that the organization is formed only for nonprofit purposes and that all the assets are dedicated to that purpose. But at this point, LLCs are generally used as subsidiary entities. Then you've got corporations, which is probably where I think you've spent most of your time. A corporation is an entity that is formed pursuant to state law. In the United States, there are several organizations who are formed under federal law, but the vast majority are under state law. So the method of incorporation, what has to go into the articles and bylaws, the way the nonprofit corporation functions is controlled by state law, not by federal law. And that's an important thing to realize when we get into the question of a tax exemption, because the IRS does not have the right to dictate how the nonprofit corporation is going to be structured. Now, with regard to corporations, there are sometimes specific state laws that deal with various religious organizations. The corporation sole is a common form that you'll find in a number of states. The idea of a corporation sole came out of the Catholic Church, although a lot of Catholic churches are no longer using the corporation sole format. But the corporation sole basically had the bishop of the church controlling the organization. So you had one member, one sole member of the organization that ultimately had the control. There are a lot of issues with a corporation sole, and most of the time the people that have chosen, in my opinion, the people that have chosen to use a corporation sole form have done so without knowing all of the detriments of doing so. One of the problems in California, for example, of using a corporation sole is that if you decide at some point that really you don't want to use that form, you actually have to form another nonprofit and then dissolve the corporation sole and distribute the assets. There's no way of merging the two or converting from a corporation sole into another type of nonprofit entity. The biggest problem with corporation sole is that you need to have a method by which you provide for a transition. So if something happens to your bishop or whoever's running the corporation sole, who is going to take over? What is the method of transition? And most state laws regarding corporation sole leave that up to the nonprofit entity as to how that's going to be done. So if you find someone who's chosen a corporation sole format, you really do need to get into that question of succession. Along with that, with a trust, an unincorporated association, a limited liability, and to at least some degree the corporation sole, you have an issue that the basic structure is not clearly set out in a default provision in the statute, which means that you can do whatever you want as far as how you're going to structure it, but it has to be set up in such a way that there is no issue with regard to how you're actually going to function. Members, directors, etc. It's not something that is set in stone. You can do it however you want, but you have to do it. So that's something to be aware. If you choose something other than a corporation, it's not going to be controlled to the same degree, the statutory degree, as with a corporation. Now that's both good and bad. It's good because you have the option of being able to operate in whatever way you see fit. It's bad in that you have to actually think that through, and it's not something that's going to be obvious to a lot of people. Now, one of the reasons why you will often find churches saying, well, we don't want to be subject to the corporate structure, actually comes from the Kedroff versus St. Nicholas Cathedral case, where the court ultimately said, if you choose to elect to be to get the benefits of the corporate structure, then you also are subject to the laws of the state with regard to how that structure operates. And because a lot of people do not believe that their church is a creature of the state, they have questions as to whether a corporate structure is really the one they want to use. Moving on, one of the other things that we talk about, or we'll be talking about during this session, is the difference between hierarchical and congregational. Once you've got your nonprofit set up using whatever form you've chosen, the next question is the internal church structure. The bottom question is there a separate higher church authority or is the authority resident within the local church? If it's a hierarchical, you have another separate hierarchical authority. For example, the Methodist Church, the Episcopal Church, the Lutheran Church, the Mormon Church all have a very clear hierarchical structure. Congregational churches, the Baptist churches are generally congregational, even if they have a denomination, and then the Christian churches, Churches of Christ, again, the individual church rules. Now, one of the things that we will talk about more is what happens when you have a dispute involving the church. Now, if you have a hierarchical structure, then it's easy to say, okay, this is how we're going to resolve disputes. We're going to appeal to the higher church authority. Congregational churches can also decide how you're going to resolve matters of disputes, but you're going to have to think about the question of to whom are you willing to submit when you actually come up with determining the method for resolving these disputes. Now, once you've chosen to your structure and you know how you're actually going to function, one of the things that we're going to talk about a little bit is what goes into the Articles of Incorporation. For the most part, it's going to look essentially the same as any other nonprofit corporation, except that you're going to have to make sure that you've chosen the correct structure. Some states actually have a separate religious corporation structure. But beyond that, I would put into the Articles of Incorporation some sort of a purpose clause that goes beyond just saying you're a church or saying you're formed for religious purposes. And I would normally put in a statement of faith. Why would I do that? Because you want to make it clear that this isn't just any church, it's a specific church. And this is what you believe, this is what you practice. So that's something to really think about when you're putting together or reviewing the Articles of Incorporation of a church. Bylaws, I think you've already talked about members, directors, and officers, but members are really a crucial issue with regard to churches, because if you remember the 14 points that the IRS looks at, one of the 14 points that they probably consider to be the most crucial for a church is having members. Now, you can have members without having them vote. A lot of churches, especially the hierarchical types of churches, have members that are not corporate members, they're congregants. And so that's something to look at. If you have congregants that don't have a right to vote, you need to make it clear in your bylaws that you have congregants. They are church members, perhaps. You can call them whatever you want, but they are not corporate members with a right to vote. If you don't make that distinction, it's very likely that simply by having members, you will give them the right to vote on various things. So need to make sure that you have that set out. Now, how are directors selected? Again, a lot of congregational churches have the members actually selecting the directors. Some hierarchical churches do a similar thing, but it really goes church by church as to how the directors are selected. Oftentimes, even with what would otherwise look like a congregational church, you may have the directors being self-perpetuating, where they elect themselves. Other hierarchical churches may actually have the whoever is chosen for the directors approved by the higher church authority. But again, that's going to be determined by your particular church. How many boards? This should be something that should not even be an issue, but I've seen so many situations where a church they'll have a board of elders, a board of deacons, a board of trustees, and a board of directors. You only need one board. And if you're going to have more than one board, one of the things you really need to consider is if there's a dispute between these different boards, who's in charge, whose decision will prevail. So that needs to be set forth.